Hey guys, Wyatt Claypool here. Yesterday in British Columbia, we had what may be one of the dumbest legal decisions ever made in Canada come down. A judge ruled after a 5-year-long court case that yes, Indigenous land title also extends to places like Richmond. If you don't know Richmond, it's a city connected to Vancouver that is a mixed urban and suburban area. But now the Cowichan Indigenous Band has land title over it, and it means presumably that if you're the government or a private resident and you want to build a house or you want to make major renovations to your house, put up a shed, you may need to get Indigenous Band Council approval by the Cowichan Band in order to do so. Because this is what already happens in places like Powell River. If you want to build a wooden dock off of your property into the water in Powell River, you may have to go through an archaeological dig. You may have to pay for an indigenous consultation. You may need extra environmental inspections in what is, in effect, a reconciliation industry shakedown. So, what this judge has done is said that those shakedowns can extend into urban areas where everyone would have laughed at you for suggesting that it would have gone to just a couple of years ago. This is absolutely insane, and I'm going to break it down for you guys in this video. But before we get into it, I just want to say if you are a resident of British Columbia, if you are a voter in British Columbia, check out the petition I have in the description of this video below, as well as pinned to the top of the comments. I work with the One BC party, and we are trying to push back on this attack on property rights and make sure that we change the laws and we try and change the charter in Canada in order to prevent these shakedowns from happening, in order to prevent people from having effectively their private property stolen from them, or they now have to share it with people who don't have any real legitimate claim to the land other than these historically wide sweeping claims that because it's historical territory, they must still have title over it and decision making powers for it. But, anyways, now let's get into it. The first person to report out on this court case was Caroline Elliott, who said on X, a bombshell judgment was released yesterday by BC's Supreme Court declaring Aboriginal title over land in Richmond, including private property. If this stands, it has massive implications for private property across BC. Read the highlighted sections for yourself. The one thing I would say, and Caroline Elliott has been very good on this particular file, well, one thing I would say is that private property already was undermined by previous decisions, like what is going on in Powell River, like what happened on Haida Gwaii, which I believe used to be the St. Catherine Islands. Those areas had already been basically fully given over to indigenous bands. They had full land title over it, which meant you had these insane stories out of Haida Gwaii, where because somebody was related to someone who was dealing drugs and I believe murdered somebody, they had their house bulldozed, and the BC government didn't do anything about it because it's the band's land. They can technically bulldoze a house that, it doesn't matter because it's their land. They can do what they want with it. Extending that logic to Richmond is absolutely insane. The idea is that the band council could potentially seize your house from you or say that you can't build a new house after tearing down the old one because they first need to do a bunch of consultations, inspections, unless you pay a bunch of money. But she suggests that you should read the highlighted sections for yourself, and that is what we are going to do with this decision. So it says here, Cowichan Aboriginal title burdened and burdens the land over which the Crown grants of fee simple interest were issued. I find that the Cowichan Aboriginal title, which is grounded in the prior occupation of the Cowichan ancestors and the constitutional protected interest in land, is a senior interest and land in land vis-a-vis the fee simple titles, which derive from the Crown grants. Basically, the whole idea is that fee simple land means that you purchased it; it's your land. But the judge is saying because the Crown is the arbitrator over what fee simple land is, meaning that it used to be Crown land. That means that because basically the judge is ruling that Crown land has basically Indigenous land title over it, that if the Crown says that you have fee simple land title, that is then undermined by the fact that Indigenous groups have land title on the crown land that was then made fee simple. So then the fee simple land has indigenous land title over it. It's absolutely insane. And this whole case is about whether or not the Cowichan Indigenous Band Council can control what the government builds. It obviously extends into this private property question because the judge admits it. The judge admits that absolutely this does affect fee simple land because the crown is what granted the fee simple land, and we are talking about whether or not the crown has the indigenous land title, the Aboriginal land title that rules above it as another area of authority on the land. So in this next section, it says, I agree that Aboriginal title is a prior and senior right to land. So they're saying it is above both Crown land, and therefore it's also above private property because the Crown is what designated this area as fee simple. They go on to say it is not an estate granted by the Crown, but rooted in prior occupation. It is constitutionally protected. The question of what remains of Aboriginal title after the granting of fee simple title to the same lands should be reversed. The proper question is what remains of fee simple title after Aboriginal title is recognized in the same land. So she is saying that because it's fee simple, that doesn't mean we'll determine the small aspects where an Aboriginal title still exists. She's saying the reverse. Let's see how much private property rights really still exist in the city of Richmond now that we are recognizing Aboriginal title over the territory. Let's be clear. This is seized territory. It is ceded to the Crown. It is ceded to the Canadian government. The Canadian government, who could do whatever it wanted with it, it then allowed people to be able to purchase the land and make it their own private property. We're not walking things back because the reconciliation industry realized that there was a lot of money to be made in claiming that they actually do, in fact, have title over large urban areas, just as they do large swaths of mostly unoccupied land in the rest of the province, which still creates massive problems with getting major projects done or people being able to just be able to control their own property. Because they're also trying to do this in the Peace River area. This is what independent MLA Jordan Keeley has been blowing the whistle on. In his area, they're basically determining that potentially like 70% of all the land in the area could have indigenous title put onto it, which means that you can't really build or do anything with it without permission, which then causes a lot of corruption issues because if you need their permission to do every little thing with your private property, well, you have an incentive structure to create a system where you need to pay money in order to have inspections done, in order to have consultations done, in order to have environmental overviews done. They can now do that, and that is what they do in places like Powell River. The of pure violation of property rights is what's going down in Haida Gwaii right now. But now I need to move on to a area of hypocrisy because one of the people who just came out and said that this is bad is somebody who set up the infrastructure for this to happen. This ruling in Richmond is based off the Haida Gwaii precedent, based off the St. Catherine Island precedent. BC Conservative leader who was the Indigenous minister under Christy Clark came out to say private property rights are the foundation of our democracy and our country. Any decision that attacks our private property rights needs to be appealed and overturned. Indigenous title and private property rights cannot coexist overtop one another. Losing private property rights on your home, your land, and undermining the rights that underpin our country is wrong. Reconciliation cannot be achieved by taking rights away from one group and giving them to another. Well, that's a very odd thing for John Rusted to say, considering that he supports DRIPA and UNDRIP. He will say that he supports repealing DRIPA, which is the Declaration of the Rights of Indigenous Peoples Act, but then he says he wants all of his policy, if he becomes premier, guided by UNDRIP, which is the UN Declaration of the Rights of Indigenous People, and it's what the current federal government uses in order to deny major project like permissions and grants and whatnot right now on a federal level. But now let's jump over to the response from one BC leader, Dallas Brody, who I thought had a great takedown of John Rusted, pretending that he really cares about what happened in Richmond. Dallas highlights, John, how can you possibly feign concern over this judgment? You celebrated the Haida Nation Reconciliation Act in April 2024, which declared Aboriginal title over private property on Haida Gwaii. And she has a screenshot from the left-wing newspaper, the Tyee, that says, when the Haida Nation title reconciliation agreement came to the legislature in April, for example, Rusted praised the Haida on the quote-unquote historic step in their long battle to assert their rights to the land. But curiously, he took the occasion to talk at length about himself and his own view of title, a fundamental dimension of Indigenous rights. Quote, this is Rusted speaking, quote, I think it might come as a surprise to some to know that I support title, he said. Then most of his audience in the chamber that day would be familiar with his record as Minister of Aboriginal Relations and Reconciliation in Christy Clark's BC Liberal government. And yeah, that's pretty bad because everything that Rusted did as the Indigenous minister, the guy who was in charge of reconciliation, set the precedent for that 2024 act that he supported, as well as what is going on now in the courts. We have the government giving large swaths of land to Indigenous, saying that they have land title over it. And that was all based on the precedent that Rusted had been setting up, where he signed 426 agreements, I believe, when he was the Indigenous minister. But I want to now jump over to the video reaction.
Just when you
leader Dallas Brody. Of course, I work with these people, but I can't help agree when people say things that are very agreeable. Again, petitions in the description below. Sign it, and if you're in British Columbia, because I can guarantee you the BC Conservatives are not going to do anything about it. Angelo Isidoro, the current executive director of the BC Conservative Party, by the way, great job, Angelo, for putting you guys $4.5 million in debt. Yes, the BC Conservatives are $4.5 million in debt right now, and their fundraising's falling off a cliff. But he, on a podcast with Mo Amir from Van Colors, a progressive podcast, he went on to criticize people like Brody, Tara Armstrong, the other one BC MLA, and then independent MLA Jordan Keeley, saying that they were intolerant of other people's opinions in caucus, and that they have to suck it up if other people are in favor of DRIPA and they aren't. But repealing DRIPA was part of the conservative platform. And then Angelo, the executive director, came out and basically said that other people have other opinions on DRIPA. Presumably that would be Alia Warbus, Scott McInnes, Peter Millibar, and some of the other woke MLAs like Gavin Dew and Eleanor Sturko. Gavin Dew, by the way, was a big fan of Kamala Harris and was actually is a registered Democrat in the United States still. But the thing is, that's like a major platform plank. You cannot have a DRIPA be a free vote. Repealing it cannot be a free vote. It is fundamentally what is undermining property rights in the province right now. And when Mo Amir pushed him on that, I played it in another video. When Mo Amir said, wait, isn't that part of your platform? Angelo said, well, yeah, it is part of our platform, but you'd have to ask John whether or not it's still something that we would require MPs or MLAs to vote on to repeal. But here's Dallas Brody reacting to the story of this judgment.
Just when you thought things couldn't get any more insane in this province, a BC Supreme Court judge has just ruled that Aboriginal title will be recognized over the private lands in the City of Richmond. Wake up, people. Your fee simple title is now uncertain and possibly invalid. And you thought you owned your land? Well, you'd better think again. This is exactly why 1BC has been raising the alarm about the threat that Indigenous claims pose to the future prosperity of British Columbia. Make no mistake, to undo the damage that this is going to cause will require every one of us to stand up and demand changes to the Constitution of Canada. We at 1BC are here to lead that movement. We will fight for you and fight for the future of British Columbia. Join 1BC to fight for the future of...
Anyway, so I want to move on to some other details from the case. We've gone over a little bit of it that Caroline Elliott highlighted, but now I want to move on and talk about some of the very strange things that were said during the course of this ruling. So this was highlighted by the former BC Conservative candidate, Brian Burgay, great guy. By the way, most of the MLAs in the BC Conservatives could be great cabinet ministers. They're actually very good conservative people. I'll just name a bunch of them. Heather Maas is great. Lawrence Mock is great. Brent Chapman is great. Brian Tepper is great. I think that some other people I'm forgetting about, and I don't want to be rude to them, but there's like I could probably name like a good 20 of the MLAs who are like pretty good to very good, and they're being held down by John Rusted, Amelia Boltby, Sturco, Dew, and others who don't actually want to be conservative. It's like they're allergic to it, and so they basically have been threatening people into not saying anything conservative on issues like this. You had Heather Maas bring ARPA to the legislature, which is a reform Protestant policy group who talks about life issues, pro-life issues and MAID and whatnot. And she had Sturco and Boltby attack her online and in the media for daring to have a Protestant group come to the legislature. That's how much of you will get scolded if you do anything socially conservative in that party right now. But here we have Jamie Sarkonik, Sarkonik. I'm bad with last names, people. You've learned this at this point. But she says, regarding private land, the judge Barbara Young, a Harper appointee, takes an ominous tone. Private land is valid for now. She also ruled that the Crown has a duty to reconcile the competing interests of private landowners and the Cowichan. Who knows what that looks like? And I got to say, sorry, to the Cowichan Band Council, and I don't believe this is representative of most Cowichan Indigenous people. This is the band, it's the reconciliation industry, it is the shakedown industry doing this with a few of the activists from the community. What did they think they were going to build there? Sorry, the city of Richmond being built in an area next to the water was violating their rights to build the same city. Were they going to build the city? I'm sorry, but a lot of these Indigenous communities are very small communities. I don't think that they need land title over the city of Richmond, British Columbia. And let's be clear, if Richmond, British Columbia was not well developed and there wasn't much there and it was just rocks, or it was just a small town with a few scattered houses, they wouldn't want it. They are going after it because there's a lot of money in Richmond, British Columbia. And if you bring the shakedown industry to Richmond, you could make a lot in consultation fees and other land disputes that you can bring to the courts. But then in the highlighted sections, we have Jamie highlighting, however, the Cowichan have not challenged the validity of the private fee simple interest, and those interests are valid until such a time as the court may determine otherwise, or until the conflicting interests are otherwise resolved through negotiation. So the judge is saying that even though the Cowichan did not actually challenge fee simple title because they were mostly going after government title, that at a later date, we can determine whether or not the private property rights really matter anymore. But the other things that the judges said basically indicate that, yeah, they would rule against it if they were in that that court case, because they've already said that no private property rights. We're not seeing what's left of Indigenous title or Aboriginal title in the face of private property rights. We're going to see how much private property rights are still active once you add Aboriginal title to the equation, basically saying Aboriginal title uber Alice. And then in this other highlighted part, it says, while I agree with BC that the private landowners' fee simple interests are valid and remain so for the time being, I do not agree that the reconciliation of the Cowichan Aboriginal title is appropriately defined with reference to those interests. So we can't actually even curb what the Cowichan Aboriginal title interests are in the face of the fact that people already own land there, people have already built houses, they've already built skyscrapers. That's cute and all, basically, the judge is saying. We'll figure out how much of that really matters once this comes back to court at a later date. And Jamie then follows this up, saying, notably, the Cowichan didn't ask the court to extinguish private title, only government title. They held back a bit. We haven't seen the full power of Aboriginal title. The judge implies here that the private property is on the chopping block next. And the highlighted part says, the only comfort the plaintiffs offer non-party landowners is their assertion in the proceedings that they do not seek to invalidate those fee simple titles. The basis on which they seek a declaration of invalidity against Richmond and the Canada BFPA could be turned against the private owners next. I'm not sure if this is also maybe a dissenting decision from someone else or like one of the lawyers, but this was said in the trial, so that might not be the judge. Jamie then says, in this specular a spectacular roller coaster of a paragraph, the judge scolds Richmond's lawyers for bringing up big picture concerns about what this will do to the economy and to the integrity of the property system. Then she agrees with them, yellow. So it's first purple, then yellow. First, it says Richmond's submission that a declaration of Aboriginal title will destroy the land title system and the LTA, wreak economic havoc, and harm every resident in British Columbia is not a reasoned analysis on the evidence. It inflames and incites rather than it grapples with the evidence and the scope of the claim in the case. Well, this does kind of matter. Judges are supposed to have judgment. They're supposed to be able to say, does this seem reasonable? There is, in fact, a reasonableness kind of threshold in the court where a judge can say, well, yeah, maybe you're technically following the law, but this is not a reasonable application of the law. You are supposed to prevent the law from being gamified to somebody's disproportionate benefit that they really don't deserve. But then the judge goes on to say, a precedent that will follow from this case is that provincial crown grants of fee simple interest do not extinguish or permanently displace Aboriginal title. So yeah, they're basically saying that your private property rights do not affect you. Yeah, and then Jamie says there's a lot at stake here. I looked up the value for the federally owned lots and found estimates for all but one. They came out to $546,485,000. That doesn't include the municipal lots. And this is just one case. Now think of all the other Aboriginal title claims. So yes, we are looking at over $500 million of just the government, the federal government's property that could be affected by this decision. This is why Dallas Brody, Tara Armstrong, actually one of our powerhouses, of course, in the party, Tim Thielman, have been blowing the whistle on the issue of what was called the reconciliation or Aboriginal industry. It has turned into an industry of lawyers, consultants, and activists to undermine other people's property rights in order to profit. And by the way, this doesn't help the average Indigenous person at all. It's not helping poverty on reserves. It's not helping crime on reserves. It's not fixing the economic disparities between people because it's basically incentivizing people to live where there is no economic development and which economic development will be challenged because there may be more money to be made in courts than actually having sustainable jobs on reserves. This is actually hurting Indigenous people's own rights because the only way the Indigenous people have rights, according to the reconciliation industry, is through collective rights through the Band Council. If you're an Indigenous person living in Haida Gwaii, you don't have private property rights either. It's band property rights. It's collective property rights. That's why the Haida Gwaii Band Council bulldozed someone's house for merely having a connection with a drug dealer and someone who I believe was a murderer. Just having the connection with them, having a family relation with them, was deemed good enough to then have a bulldozer destroy somebody's house. Did the RCMP investigate? Did the government declare that we need an investigation of the Band Council for what just went on? No, they are completely mum. And yes, you're going to have the Conservatives making a couple noises about how this is bad, but they don't have a leg to stand on. They are basically trying to walk a rhetorical tightrope where they keep talking about how it's very important that we pursue economic reconciliation. Oh, but we oppose DRIPA kind of, but we also support UNDRIP. But Rusted was very happy with the Haida Gwaii Act, but he's also very proud of his past in signing all these land deals, but the land deals are now going too far. So they'll come out and say, well, the Joffrey Lakes decision saying that only Indigenous people can be in the in Joffrey Lakes provincial parks for 100 plus days out of the year, that's wrong. We shouldn't do that. But then the next breath, they'll say that DRIPA should be defended, that we need our DRIPA land, like that DRIPA legislation needs to be recognized when making decisions. I think I have something to this effect. I just need to pull up here because we had one of the we had an Alia Warbus basically come out and say this, that we need to be respecting DRIPA in our legislation. Here, actually, I have it right here. And so whenever I hear people saying, no, the party's still against DRIPA, they need to reconcile that claim with the fact that their House leader, yes, is saying stuff like this when opposing things like Bill 14 and 15. The Conservatives scuffed the opposite. Are Bill 14 and 15 good piece of legislation? No. But the Conservatives argued against them from the perspective that they were not pro-Indigenous title enough. Check this out. This is a Conservative MLA.
There needs to be a recognition that it be afforded the time it takes to have the alignment with DRIPA, and that Indigenous leaders are going to be on side with any changes to legislation that's going to affect them. That's very clear.
So we need Indigenous leaders to be on side with legislation and probably any other legal decisions that could affect them. So now, in that context, we must now align with Indigenous leaders over anything that happens in the city of Richmond because they have land title over that land, and presumably it now affects them. This is why this kind of philosophy is toxic and dangerous to private property rights. We should be trying to make sure everyone has private property rights, whether it's Indigenous Canadians or it's any other Canadians in British Columbia. They should all have private property rights, and that's why there needs to be constitutional changes made in Canada. That's why we need to change legislation on the provincial level. That's why we may actually need to use the notwithstanding clause in order to do an end run around these ridiculous decisions that are being made. And I know that Indigenous issues are one of those areas where you're not usually supposed to be able to use the notwithstanding clause. I would say just use it anyways. Let the courts try and enforce its decision if they say you can't do it, because goodness, this needs to be pushed back on. Anyways, so with that being said, that should be the end of the video. Again, guys, petition is in the description below as well as pinned to the top of the comments. I will see you guys next time.